Welcome to Term Talk. I'm Hamid Khan, Judicial Education Attorney at the Federal Judicial Center. In each episode, we discuss Supreme Court cases likely to have the greatest impact on the lower courts. Joining me are Erwin Chemerinsky, Dean, and Jesse H. Chopra, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Michael McConnell, former judge on the U.S. Court of Appeals for the 10th Circuit, Richard and Francis Mallery Professor of Law, and Director of the Constitutional Law Center at Stanford University. Thank you both for joining us today. Today, we are discussing Glacier Northwest versus International Brotherhood of Teamsters. The questions here are whether the National Labor Relations Act preempts state tort law. Michael, can you give us an overview of the NLRA and how it applies to the facts of this case?
Yes, I'll do my best. The National Labor Relations Act prohibits, among many other things, unfair labor practices by either the employer or the union. And this is about supposed unfair labor practice by the union, namely failing to take reasonable measures to protect the employer's property. A quick foray into the facts. This is a cement producing company. And once cement is so-called batched, that's the word that they use, and put into the trucks, it is a highly perishable commodity. And in this case, the union, knowing that it was going to go on strike and knowing that the cement is perishable, nonetheless allowed the cement to be loaded into the trucks and then declared a strike, which meant that the cement that all of that cement was destroyed. And the employer sued under state tort law for this. Now, back to the National Labor Relations Act, it gives exclusive jurisdiction to the National Labor Relations Board, we call it the Labor Board, to adjudicate these matters. And the problem is that sometimes state law, not labor law, but in this case, tort law, other laws may both apply to the situation. And so the question is, when is state tort law preempted by the National Labor Relations Act? And there's a somewhat unusual doctrine that arrives in a case called San Diego Trades Council versus Garmin, which holds that state law is preempted not just when there is a conflict between federal and state law, but when there is any possibility of that, any reasonable possibility of a conflict. And the Washington Supreme Court here said that the state court should stay its hand and let the labor board act because there was a possibility of a conflict. Maybe what the union had done with respect to the cement was protected, and we should leave that to the labor board to decide. But the Supreme Court, in an 8-1 decision, held that this conduct was clearly on the impermissible side of the line, and therefore the state court did not have to stay its hand.
Erwin, what did the court say, and why didn't they wait for a fact determination from the board?
Justice Barrett wrote the opinion for the court, and she focused on just the language that Michael referred to, as to whether the strike was arguably protected. She said, since the court decided that this strike was not arguably protected by the National Labor Relations Act, there was no need to wait for the National Labor Relations Board, and thus the court said the tort suit could go forward. They said that the union here executed the strike in a manner designed to cause economic injury, that they initiated the strike after the cement was already mixed and loaded into trucks. They prompted the creation of a perishable product. They didn't take steps to mitigate the harms from their strike. They didn't alert Glacier that the trucks were returned. They didn't follow Glacier's instructions as to how to mitigate the harm. And therefore, since this was not a strike that was arguably protected by the NLRB, the tort suit could go forward. Justice Jackson was the only dissenter here, and she said that preemption is important here, that when there is a complaint filed, as there was in this case in the National Labor Relations Board, that should be for the National Labor Relations Board to decide if the strike is arguably protected. Preemption is a way of pausing the state tort suit to let the NLRB determine. What here Justice Jackson says is that the court's decision really thwarts Congress by not waiting for the National Labor Relations Board to act. Justice Jackson says there's other instances where strikes have caused loss of perishable products, like milk and eggs and produce, and nonetheless, the strikes have been deemed to be arguably protected, and there's been preemption. Justice Jackson ultimately says this is a new standard, and the court shouldn't be adopting it here. It should be for the NLRB in the first instance to decide whether the strike is arguably protected.
Erwin, what are the takeaways from the opinion?
Well, a couple. First, I think this is going to cause real confusion as to when Garmin preemption exists, and it's for the board to decide if the strike's arguably protected, or when tort suits can go forward. Also, as I alluded to, Justice Barrett's opinion articulates a standard. It says that there can be liability, there's not preemption, when the strike is aggravated and causes imminent foreseeable harms. All strikes cause economic harms. That's why they're effective in terms of protecting labor. The question is, when can the union be held liable and when not? There's no right of union members to throw a brick through the employer's window or burn down the workplace. On the other hand, undoubtedly, there's going to be costs to strikes. The standard now is that the union is liable if it's aggravated and it's imminent foreseeable harm. It'll take a long time to figure out what that standard means.
Michael, would you add to these takeaways?
Well, I mean, Erwin is of course right that there's going to be a lot of confusion, but Garmin has been producing confusion all along. In fact, the Garmin opinion itself describes it says these applications are of a Delphic nature and will have to lead to lots of future litigation. So that's been true all along. What I think, but I think the music of this opinion really is a bit different. I don't think there's any change in the holding. There's no change in the law, and the case itself is highly fact specific, but it does have a feel to it of tilting more in the direction of allowing state law to operate. And then I have the sneaking suspicion that 10, 20, 30 years ago they might have treated these facts in a different way. The most interesting question is the one raised by Justice Jackson in her dissent. And by the way, this was the first single justice dissent that Justice Jackson has written on the court. And that has to do with the fact that after this tort suit was filed, the general counsel of the NLRB did, in fact, file a complaint having to do with this. So if it's you can say that renders it obviously arguable if the general counsel of the board thinks that the board needs to take it up. The majority in the case in a footnote said, well, no one has raised that, and noted that even the general counsel did not argue in the case, or in the brief said that that should not be a basis for decision here. That's going to be, in my opinion, the big issue going forward is how to treat general counsel complaints in the context here. Justice Jackson's position could very well prevail in the long run once it's actually raised.
Thank you both for joining us.